Our clients are doctors who are either OBGYNs or OBGYN hospitalists who work in emergency rooms. And the reason our clients have standing is because from 2000 on, including in 2021, FDA acknowledged that the restrictions, the safeguards that it was removing on the abortion drug would mean that more women suffer harm and end up in the emergency room. Again, women come into these emergency rooms suffering from abortion drug complications, and our doctors have a sincere conscious objection to facilitating abortion, to potentially ending an unborn life, and those sorts of things. So our doctors are harmed by FDA's express acknowledgement and conscription of those doctors to deal with problems the agency anticipated.
The court's mifepristone case has the potential, obviously, to upend how drug approvals function if you can challenge drug approvals years or even decades after the fact by asking judges to sort of second guess the evidence that regulators have meticulously reviewed. That sets a pretty important precedent. From the standpoint of access to mifepristone, the case could be a big deal because if the court even sides with the Fifth Circuit, essentially saying that the FDA didn't have the authority to lift restrictions on access to the drug in 2016 and 2021, that would render pretty much all the doses of mifepristone on the market potentially misbranded and mislabeled, which could mean, I think, months of disruption in terms of the drug being available. There's a possibility that the court will address the Comstock Act, which is a 19th century obscenity law, which some abortion opponents are hoping the Trump administration, if there is a second Trump administration, will treat as a de facto ban on all abortions. So there are a lot of explosive possibilities that we could see in the case.